but also because the decree was supreme as well to the Constitution. And definitely we know the spirits in which the APRC junta came, and the various human rights violations that were committed, as you alluded to. So the spirit of decree number 1 was against protection of fundamental human rights.
I
don't agree. Decree number 1 did not suspend fundamental human rights.
Thank you very much. Perhaps we can move on, and I will allow the Commission to decide on that point. We've looked at decree number 1. Can you just guide us through the rest of the decrees that you assisted the junta to pass?
Decree number 1 decree mi yalanko yete dablo to wala kono mi yalanko wo junta man sakunda ni wolle de dano.
And to buttress my answer in respect of the non-suspension of decree, the fundamental human rights chapter of the 1970 Constitution.
Anin kanna kuma kango bambandi ka foko decree number 1 amang hadamaya nyanto la kunya lu den ka ben 1970 Constitution kono nyaming.
The Monday following my return, that is the 29th was on a Friday. On the Monday, a state council rushed to my office.
State council office.
Lawyer Mansalam lawyer Mo.
And said that managing directors had been arrested.
Akoya managing director mutale.
And were sort of being paraded on a truck.
Koye bulandi motobale kono ibe yitandi kankata.
In Banjul.
Banjul sate kono.
So I rushed to State House.
Nyamoto tata State House.
Because when I met the chairman,
even
though he was talking about setting up commissions of inquiry, this is one of the things he said in his discussion with me. He had specifically said there would not be a witch hunt. So I was ushered in to see him. And I protested the arrest of the managing directors. I told him that this was contrary to his assurances that there would not be a witch hunt. And particularly their humiliation by being put on a truck just based on mere allegations of corruption. So he called in Lieutenant Sanasabali. And Sanasabali said that these people were corrupt and were criminals. That they had been taken to Mile 2. I stood my ground and reiterated and remonstrated with them that they could not put people in Mile 2 without trial. Finally, they agreed that the managing directors would be released. And he promised to call me and confirm when they were released. And that evening, he phoned to say that he had given instructions for them to be released. I could not have done that if there was no fundamental rights provision in the Constitution, or if fundamental rights had been suspended.
ye hadamaya nyantolu be den walla ye dabondi kolu kono e mantara kerin kotake tombi wol kolu te kenola.
As far as I was concerned,
ntele kundi ngola karola,
and more importantly, as far as decree number 1 was concerned,
adun ka kola kuma ya jube decree number 1 fon fanana karola,
fundamental human rights chapter in the constitution was operative.
Hadamaya nyanto sabatindolu ning abaru malu banko kan utumode ibe lorinne.
And we, that was why consistently we emphasized that human rights had to be respected.
If
I can just make a comment there, Mrs. Bensouda. The operation of human rights and fundamental rights was not protected. It wasn't protected through the provisions in the decree or the constitution. This was a special effort you made to free these individuals. And that is why they were freed. That is not how fundamental human rights operate. They should operate freely by law or by the constitution. And as far as I'm concerned, the decree number 1 superseded all of those provisions of the constitution. And just to preempt you before we get to decree number 3, if you remember the case of Chongan and others, they were acquitted and discharged by a magistrate. They were basically listed in the list that was attached to decree number 3. And they were security detainees. Despite the fact that they were acquitted and discharged, the overriding power of decree number 3 applied in that instance. So therefore, like you said, even though the courts were functioning, as well as the rights under the 1970 Constitution, however, the decree superseded them. Was that a very long question again?
It was a statement.
I'm going to ask that you agree or disagree with the statement then in that case. I'm putting it to you. Let me shorten my question so that I can get a direct answer from you. Do you remember the case of Chongan and others?
Not the details. What is the date of the case?
I do not have the date of the case, but this was sometime, I believe, in 1995, if I'm not mistaken. I'm sure you're aware of Chongan and others being arrested as security detainees immediately following the military coup. Were you aware of instances where security detainees were discharged or acquitted by courts, but that could not happen because of decree number 3, which you drafted.
Foi hakilo bakane ko mol mi yalan ko ko tanko bunda mol le muti ye samba kiti ndiro la kiti ona tebula but wo bula ro ni amanna sembo soto no kadu dikri le bije mi yalan ko man sakun a wo man sakun dambe kering ye fan sujini wo dikri la and wo dikri etele moti mi yalan ko ete fongle ya safe.
Which provision are we really talking about in decree number 3?
The strategy mal foga in decree number 3.
We're just looking at the generality of decree number 3.
Decree number 3.
If you look at it, it states that the supreme power resided in the council to detain members of the security forces. And that because the decree overrided the Constitution as well as the courts, just like in decree number 1, the hands of the courts were tied. If you look at 2.1, I'm looking at decree number 3.
2.1 of which of the decrees?
Decree number 3.
Decree number 3.
Yeah, that is state security detention of armed and police personnel. Yes, it says that where the vice chairman of the armed forces provisional ruling council, and that is the general order to make detentions, to order for detentions.
Chairman sa fono le ko wala la wo junta chairman wala nyaton ko nyinga sa fono le ko nyim mo tanko bunda mo nse mutano le na tara ko chairman ya jelo ko la wo mutaro nyinga jarta la pour ye muta asina kango di ko ye muta.
It also states in subsection 2 that in fact the vice chairman may direct the place that the person is going to be detained.
And fana sarta do fana tato bala mi ala be chokini wo bala mi itandro ke ko mi alon ko wala sinno be chairman no wose ya marodi no la komi nyimol mi yalan ko ye muta wallen tanko bunda molti isa fono la dinkral to mi yalan ko nyanta ke mabo wallato.
It goes on further in subsection 3 to state that the conditions of detention are also determined by the vice chairman, including even as to confinement, maintenance, discipline and punishment for breaches of discipline.
A continue to fan kafo fan ko min dinkral to mi yalan ko nyanta ke mabo damento wo be sembo tata chairman no malanko lebul fo min tate la kulu la karola la taranyala karola nyanta min lale kan.
And we all know that even in the case of Chongan
and be alone ne min keta Chongan la karola
and Mama Cham and others,
and Mama Cham na munyol
during the period of their detention
wato mi yalanko be muto kono no
on the 6th day of September 1994,
wala kada September karoti woro 1994,
members of the junta, except the chairman himself, went into mile 2, subjected them to brutal torture, as well as a mock execution. And who knows if that may not be a lawful interpretation of maintaining discipline and punishment and all of that.
Anjumala ba fola no ko munyale timi alonko isafo no la ko komi betilingo anin ka foko ka kuluo la mol ka nyinem silo timi alonko wala nyanta kata.
But I assume that would be under the exclusive purview of the vice chairperson the vice chairman to interpret.
Bare ngalo no ko wobe tuta chairman no nyine bulu wala vice chairman no nyin komi abo ko tala nyandu le ka foko ka firing.
But Mrs. Bensouda, this is the decree that you drafted, and you gave extensive powers
Mrs. Bensouda
to members of the council.
In decree luani, fenne mi yalanko ite fongole ya deda and ite fongole nata murunko de yesembo di nyimola.
Decree, sorry, you expect me to respond, I suppose.
Of course I do.
The military officers, Chongan and others, were already in detention when this decree was promulgated on the 4th of August 1994.
Let me just interject there, Mrs. Bensouda. Yes. Sorry, I don't want to lose this point. We've already discussed that the decrees had retrospective effect.
And I'm
putting it to you that the reason why they had retrospective effect or retroactive effects is because the council wanted to give some sort of legitimacy or force of law to their actions in case somebody decided to challenge it.
Yo get dalilol min kama wala nyindiko isaje tol council mol fon isaje ko ye kuo kuke ye tilimbalia ko wala ye kuo kuke andong ya ko milla natara wo maril pareta pour que samba kiti dulat e be min kala dore be fan suje la ni la nyin decree lu walela.
Because even though the decree was not passed when that action took place, but then the law gave it validity.
But hani wo be kanko ayatara fon kabri bo ko wol nyin ke kan ayatara nyin decree nyin amanlo but hadi say nada na sembonti ya ni luala
because of its retroactive nature.
Katu ko mine wotina katu ya murundi ko mala ko min ko wol min be katano.
Learned Counsel, with respect, no law can give validity to torture.
Luata keri meye nyin tonya yandika momuta ka tajiriya.
These military officers, as you mentioned, were already in detention.
We had
instructions to draft decree number 4. At least for the future, just taking the sections that you quoted one after the other. But what decree number 2.1 made possible, at least for those who were not in detention, that they could not be detained without a detention order. Decree number 4, or section 2, subsection 2 and 3.
Decree na ninjango alabunda fulanjango fanana bunda lulula fulanjango ni sabanjango
did not empower anyone to torture persons in detention. To the extent that the fundamental human rights provisions were still in force. The decree assumes that all detention would comply with the fundamental human rights provisions.
Decree was called burning sartolu nyanta tala nyola lemenket hadamaya nyantoluti.
So to say that because the decree was given retroactive effect, that probably legitimized torture that was going on. Respect is not correct.
What I was saying that it legitimized the actions of the government. Especially when it came to it certainly legitimized unlawful detention as we know it in the Constitution. Because the procedure in which they detain people, and the evidence is quite clear here, the TRRC was definitely not in consonance with the provisions of the Constitution. And that, in my view, paved the way for other human rights violations such as torture.
Andu ntela miraloto anata muna wulu wala nyintiko kasilo di nyantatinya dol miyalanko woleketa molla.
Decrees cannot legitimize the actions of the Armed Forces Provisional Ruling Council. It cannot legitimize torture. It cannot legitimize detention. What legitimize? Sorry.
Dikriolu tenying keno la ka foko ka tilindi wala ka kesartoti pour ka molu muta wala ka molu tajreya wala ka kujawolu ke molla ke dimindi.
And the Armed Forces Provisional Ruling Council knew that the only legitimacy they can get for their action during the transition period
andu sojarolu tumo itelia lonko ko men si itelu lakolu sambano ay keko kutilindi ngolom itela mararo kono
was to have an indemnity in the Constitution of the Republic of the Gambia.
Wolem ka bunda londi Gambia la Constitution o kono me ya lonko wolebe kantaro kala molu la men ya lonko ni yo kolu ke satara kute kelela.
That is why they went to the extent of ensuring that we had the second schedule to the Constitution, indemnifying their actions during this period.
O dalilo le ya sabu itata ka bunda fulanja nyi murundi na Constitution o kono me ya lonko wolebe itali kantala ila kuketa lutobe menu kala wo sartol fanan la karola.
And let me also remind you that legitimization must have an objective yardstick.
Ko mbenyim fanan fala ko ka kotilindi ka ke kuti me ya lonko ka ke ko kutilindi ngolo wo fanan ayala sumandalu sotolede.
A decree which is made by the military cannot legitimize what the military does. It's the decree is made by them. They cannot legitimate their own actions. So legitimization connotes that some other process is used to give validity to something a person does.
Decree olu nyili ate keno lako itel fangol yo decree ol dera pour que itel fangol law ku ketalu tilindi. Bari wo kule itandi ko kule be dendinga la meya lonko itel seo men keno wala mnie memmenke wo decree olu sike kuti si denno menula.
So with respect, Council, legitimization in relation to decrees is a misnomer.
Woto ni ajibe Council ka kulu tilindi ka fo aya tembendile sartol la karola. Woto mu kule timeya lonka ninyan tolu man tembe.
It is the Gambian people in the Constitution 1997 Constitution which supposedly went to a referendum that legitimized the actions of the AFPRC.
Birin Gambia no liye kon referendum o nyinke carte o fay hani fo wo sartolu menu dunta 1997 constitution o kono wala olu sembentu ya ke londi pour ke kuti men sitama.
And from 1997
between 1997 lungulul
those provisions in the constitution legitimizing and granting indemnity to the AFPRC remain in our laws.
Wala ya sabu sarto lumbeni itelikanta ke tankandi tilindiroma wala tutalla constitution okono wala ya kendi itella kuketalu kumanna boje mensi ke tolula kafo ye nyineke.
That is why Yankuba Toure was able to raise it.
Wala na Yankuba Toure ya kangobulindi ka okuma kangulufo.
And if you look at the judgments of our courts consistently from 1997, they have excluded themselves from having the jurisdiction to determine the legitimacy of decrees.
Grune ajube kabo 1997 kiti teulu men beketan na banko kang. Woto ninkumu itelie fam bondile ke fanjam fandi wo sartolu lako ulmu kuleti men ya lonko as keno ko kusi soto men se ke tolla wala bulusile kang.
So I think it is wrong to try to infuse decrees with an authority that they don't have. As lawyers, we know this about law. Law is merely a command that can be enforced by sanction. Were the decrees law during the transition period?
To the
extent that they reflect commands which had sanctions, which had consequences if you don't abide by them, those that were directed at people. Maybe you can call it law. But to the extent that the Gambian people did not have the military did not have the consent of the Gambian people to make the decrees, then they were not laws. That's a philosophical debate.
I was about to say that, Mrs. Bensouda. Looking at the practical realities on the ground, as far as the Gambian public was concerned, the decree certainly had the force of law. As far as the military junta as well was concerned, they ruled by it and used it as law operated in the normal setting. And by these decrees, remember, Ms. Bensouda, you drafted them, they were equipped with legislative, executive, as well as judicial powers.
And Ms. Bensouda, you decree me kafoteng, and you take a moti mialanko italadda. Yes, symbol like a mialanko and kitty bunda symbol, lua deda symbol, and ning mialanko mansakunda nyatonko la symbol fana.
And these decrees actually validated their own unconstitutional actions.
And fana nin decree ketafeneti mialanko ye londir ke kol mialanko akamtaloko droning banko lua bukuba betamaka.
And in your position, you helped them to achieve it.
And do it from kundingo watu minebo makamoto iketa multi mialanko ye demale pour ye kol tamandino wanyama.
Well, the premise of your question, if the question is whether I helped them, that premise, of course, is wrong, and I don't agree with it.
Kafo nyinin karo kono kafo kufa fodu ntele imako yukulu tamandola natara wale mude woto manso woto la mbafala ko woto dal amanke kuti ntenya ko to mentilinta.
And I respect your answer, Mrs. Bensouda, and I will allow the commissioners to draw conclusions.
Ela jabiro mba bunya la bakala and wakang mina abula commissioner bulu police jiberke ya woko nyintame ya jibe.
The decrees did not validate anything done by the council. They did not need validation.
Dikriolu mam fewo fendi bambandi ka londi ka foko nyimuku ketalti council nyin nakarola. The
decrees provided a framework for them to operate, in which they operated. It was created by them. It was enforced by them. It was amended by them when they saw fit. In fact, even where the decree said they could not do something, it did not prevent them from doing it because they had the power to do it.
Then one might ask, Mrs. Bensouda, then what's the point? What's the point of the decrees if at the end of the day they would have done what they were going to do without it, that they were ruling anyway without the power of the decree? Then what was the point? What was the point for all of the framework and guidelines that you presented in the decree in that case? Because they were not bound to follow it anyway.
What is time, Ms. Bensouda? Most of you karo kenol. But in saying you'll more let me uncle decreeing, Hanatara Lota, what a balla, it will left a cuckoo, Bakela, Fatata Insular, Farmantan Insular. In my
view, I mean, you might as well not have dirtied your hands by touching them. Just let them do what they're going to do.
Until a miralota, Imanya Dakalanunje for a bull nondi, the Union Silla ye fell it will be min cake a walker.
I do not consider my hands to be dirty.
I
do not certainly consider my hands to be tainted.
But
it's a fair question to ask then, what is the point? I suppose it's convenient 25 years down the line to be asking those questions. Were we all to abandon the country and leave it to Yaya Jammeh and his cohorts? Should I have resigned as Solicitor General? Should I even have stayed in America? These are all hypothetical questions 25 years down the line. At that time, having worked in the ministry for 5 years, Sorry, for 14 years. 14 years at that time, having been Solicitor General for 5 years.
And knowing
that the situation we found ourselves in was not unique to Gambia. And taking a point of reference from how other countries, Nigeria, Ghana, Liberia, Sierra Leone, how all of them have dealt with the situation.
Ko banku dolu ya akwoke nu nyamimbiri aketela bankolu kang menube ko Ghana, Nigeria ananyom banku kotengolu niyo santingolu jube.
I took the decision
ngawo kangota nyine kang
to come back
purka murunang
and Solicitor General
and
continue to work in the public interest, as is my oath.
Solicitor General purka continue do ko la jama molu toyala wairi ngakalioleke.
So, in your view, you were some sort of savior, Mrs. Bensouda. That's the picture I have in my mind when you describe the situation where if you had not actually intervened, this country would have gone down the line of chaos and anarchy. But for your intervention,
coming ndala miralo to ngaje nyame wala nyintiko komi natara no itamanne dabula nyunko konono deno nyim banko be kala bankule de mialan ko kairo nin tenku ngote tarano nin banko kan wo wato kon.
Savior, I wish I was. No.
Ka fo kanandirla ngam asidia nyunu ngakewti hani mankewti.
I really wish that the military who had the responsibility to secure the safety of this country
I
was no savior. However, the country was in anarchy. And what is anarchy? Was in a state of lawlessness. Where soldiers can knock on your door and throw you in prison. Other countries put in a coherent framework so that the military could interface with the public. And that's all decrees are supposed to do. Create a framework so that people will know what to expect from the military. And hopefully, the military will also understand the limits of their own actions. But let us not fool ourselves. The soldiers were in control and could do whatever they wanted. The decrees did not enable do anything.
But Mrs. Bensouda, it's very clear that the situation you explain about regulating and stabilizing the situation, I mean, it definitely did not happen. Perhaps that was your aim and that was your objective, but it definitely did not happen. And you have also confirmed that because they did what they wanted. Do you have any regrets?
Ms. Bensouda, mimbije wala nyinteko ita natala nung pruka demarke isajo kuolbe lari nun nyamin tinyarol mimbe kering abesebo wala mwila hamendatu nun barkabri nata inata ajele ko wo kuol nying wo hamendal nying imanna wo natol timandino sambe nyini ngala mina foy ni misata nyung kuol lalabang milketa.
Regret about what?
Kanimisa munna?
Specifically.
Tombondiroto kanimisa munna?
Regrets about drafting the decrees.
No, whatsoever, none.
Okay, thank you.
A framework was needed.
Even though it wasn't followed. And it was disregarded, as you said yourself.
Not everything. I did not say all the decrees were disregarded.
You said the soldiers did what they wanted to do from the beginning, even before the decrees were passed. So therefore, what was the point?
Let me repeat. The point was to create a framework within which they could operate, whether they followed it or not. That was the framework.
Sarto momenti wala mnyintiko kakuolu sambanya ning atamandinya parendi. Itatabula wonoma bang, imantabula wonoma bang, bari ninku de data me yalonko anyanta kela wole nyama, adedata wole kama.
So even if it served merely decorative purposes, it should just be there as a guideline, even though no one was guided by it.
I think it's a wrong opinion to say that they serve decorative purposes. Just to give an example, Decree number 1 enabled them to, although they had made a declaration about the cabinet.
Decree number 1
Decree number 1 gave them the structure within which the cabinet members could be appointed and could sit to address the myriad of issues that had nothing, that the country needed to be addressed, that had nothing to do with the military.
Decree following wole silo itandila inyanta kolu tamandila nyami inyanta kolu londila nyamin me ya lonko itella mararo kono be kolu tamandila wole nyama decree following yo bundale yele itelie pour salon be kolu sambala nyami.
The decree also enabled the government to know that it will continue to function under the laws that were in place.
O decree fanane nyi itandila ko ibe tamano lale lua lukoto menia lonko wolebe loring inyatili nyal.
In other words, decree number 1 enabled the public to know what the situation was and enable life to go on.
Decree following na fananata jama mako ipuri ya long munebe caring anim fanam puru molu la sinya nim balunya sitenteng.
In other words, decree number 1 was the MOU, Memorandum of Understanding, between the people and the military, if I may put it that way.
Ninsa fono wonyama decree following wole munyo fahamu county jama molu ni sojarolu tema wotembo.
Just like a constitution is the memorandum of understanding between the people, the governed, and the governors.
Constitution munyo fahamu county nyaming jama molu iniman sakunda ning maralu bundalu tema.
So we should not infuse it with some other, some other attributes that.
Yeah, Mrs. Bensouda, just to conclude, really, certainly it is clear, even from your own testimony, that the junta never had the consent of the public to do what they were doing. So I don't see how you could call that an MOU between the people and the junta. You said the government was illegitimate, and we've gone through all of that. So I don't see how that could be an MOU.
Ms. Bensouda, comme ifon ya fanyame, nta maje comme ka faname fo comme banko loi nying buko banying woning mol tema comme iko mu feneti miala ka fa memorandum of understanding wala nyomo yole be kering da mol tem o man ka fenti miala ka keta wala nyam bunya be kamala.
But in order to
it's a good point
bunda nyimalam
that you make.
Thank you for acknowledging that.
The memorandum of understanding did not require the consent of the people. That is true.
Not that it did not require it. It did not have the consent. The people never consented to this.
I think we are saying the same thing.
I'm not too sure, Mrs. Bensouda. I doubt if we are saying the same thing. I'm saying something very different.
It did not require the people's consent because they were ruling by the barrel of a gun.
And the people never consented to that.
Sorry?
Sorry.
I mean, one can debate all these issues, mostly philosophical, but let me make it absolutely clear. And I would like to underscore it. I take no responsibility for the actions of the military. And for those of us who try to stabilize the situation, I think we, in fact, are entitled to commendation. I feel neither tainted by what happened or the role I played. And whatever I did was entirely consistent with my duty to the country and my duty as Solicitor General or Acting Attorney General. Anim fanam palaso membembulo tumo attorney general makamo anio fanana sartol nin tarambulo lutata nyolale.
And I understand your point about not taking responsibility for the actions of the AFPRC.
No fananga fahamo kele munati ne mansong coming ning AFPRC mansakundani wala njunta nyinti la manyal miyalanko ya wala kenu.
And let me just
let me just finish my point, so that I don't lose my thread of thought, please.
But let me just
finish, please. Please, with all due respect.
I'm at the listening end, so I'll give you priority, yes.
Thank you very much.
Yes.
I really appreciate that. Despite the fact that you're saying that the AFPRC did not actually you've succeeded in helping me to lose my trend of thought, which I'm sure that was your
I'm glad
your goal.
not really. I'm glad you understand my difficulty when you make these long statements and expect me to answer.
Okay, go ahead and answer, and then by that time
I just wanted to add, and I take no responsibility for the decrees. I take no responsibility.
Very well. You have now reminded me of my question.
Yes. I thought you were going to, in fact,
yes, in that.
Yes.
Yes. In terms of coming up with the concept and the idea, the blueprint for the decrees, I understand that. But do you not take any personal responsibility for assisting in their drafting? Coming up with an actual decree and placing it on the table of the junta?
I don't understand why I should.
They had no know-how, they had no skill to draft decrees. I doubt if they could have made an effective review of those decrees at that point. They just took whatever you said, as far as I'm concerned.
It all man londi soto komi word decree ni nyanta ka de da nyame. Andu na taro num fa yel fellon nu jefa. Denu kabi wato minete ya de da be min kala ni ba sen kan jibe la ka jibe yemin de da. Bari mo fon keno.
The suspension of the constitution, suspension of the courts, and all of that.
Because kiti dunkral deng ka bankola bukulua ba fana deng.
But it was reiterated in the decrees.
But why
was there need to do so? If their actions had force of law anyway. That's what I'm trying to understand and reconcile with. And I think that the general public as well really would like to understand that. You know, as you said, sometimes there can be a philosophical debate as to what is law and what is not, but in practical terms, what was operating in this country?
But komi kuol mi yalan ko wolbe ke kan num banko kan wolem kuoti.
What was operating in this country before the decree was nothing. Nothing was operating.
Membe tama kan ni banko kan num me yalon ka manke oti what a fenti.
When I came back, nothing was operating. For the 1 week, the military were doing exactly what they wanted. And people did not know. And people did not know the framework within which, what was going on, the framework within which this military were operating. I call that anarchy.
Bensouda,
so maybe I don't understand
the framework question. Really had nothing to do with what they were doing, because they continued to do what they were doing anyway. The framework did nothing to limit them or restrict their actions. They continue to unlawfully detain people, they continue to torture people. Even after passing of the decree.
So
what was the framework all about?
You must remember also, I mean, I agree that they continue to do what they wanted. So decree or no decree, they would do what they wanted. Right? You must recollect that the vast majority of the decrees that were passed during this period had nothing to do with the arrest or detention. These were just regular decrees that would have been passed in the National Assembly for the good functioning of government.
But for
now and for the purposes of the TRRC,
no,
it's
very important to put TRRC cannot be the issues of the decree in the TRRC cannot be handled in isolation. There wasn't a set of decree that had a life of its own that violated the rights of the people, and another set of decrees that were applicable in terms of the functioning of government, and so on. The decrees were decrees. So yes, when it came to the decrees that affected, the liberty of the subject, the sanctity of the human being. This is what the TRRC is looking at, but it should not be looked at in isolation. So I'm quite concerned that the decrees are being infused with some sort of, I don't know, attribute that don't exist. Decrees were just rules that were put in place. Now when it came to...
TRRC be jube romen ke kan wolem ka jube o dikrilu ye londi ay men sababu akola anin akata menti ibewle jube kan pour ka kusanu soto je men muto nyati dikriolu ye men sababu ani mam men sababu bar ni aji be fanan wolu kolu mukulleti men ya lon ko nyilu bela kolu ke kan dikri bi soto ndaban dikri man soto ban itel bela kolu tamandi kan nyaado nyama hani wato me o dikriolu mallo.
Because of our mandate, sorry, Mrs. Bensouda, because of our mandate to investigate human rights violations.
I agree that there are a set of decrees. There are a set of decrees that, of course, are crucial to your mandate.
Yes. We must focus on those.
Yes, decree number 1 is not one of them.
I disagree.
Decree number 1, yes, of course. The decree number 1 merely set the basis for government by the military.
Decree following kolu lanya le yitandi sojarolu la inyanta ilamansa kundata man.
What about decree number 3? Do you agree that there was room for the junta to violate human rights through unlawful detention?
Decree number 3 nyundum foya mera we silo di junta la priya hadama dungo la nyanto tinyabang.
No, in terms of Silodi, as he put it, it did not...
I don't understand Mandinka.
It paved the way.
It paved the way.
You are agreeing that it paved the way, or you're not agreeing?
No. They were already violating human rights. What the decree did was to set down a procedure which should be followed if people are to be detained. There must be a detention order. Yes, it did not take away the right of the vice chairman, his discretion, which he refused for it to be taken away. It did not take away his powers to deal with the detainees in terms of where they should be remanded and so on. But it put in the minimum that I think we should be, I and Cherno worked on these things.
Decree follow the lomenti, wala mnyendiko. Kasilolu nin tarambulolu londi, ning itelu sonta nung purka tama menula, meni alonko, walebe kela kukendolti, isi mararo keno nyami. Ntani Cherno denta ngao silo leduku, meni alonko, walebe kela tarambulolu.
Ebe Cherno Jumale, eka Cherno Jumale fote.
Oh, Mr. Cherno Jalo, QC. He's now a Supreme Court judge.
Supreme Court
We grew up in a democratic, as lawyers, we grew up in a democratic context, in a context where fundamental human rights were supreme.
So how
could you put your name to these decrees, Mrs. Bensouda, taking that into consideration? I mean, with everything that you described about the democratic setting of Gambia and respect for rule of law and human rights, and then you assist in drafting, or I would say that you drafted these decrees that suspended the constitution.
Kominata silol mi itandi komi Gambia banko kan demokrasi katama nyama hadama dongol la nyanto hani wobe etenate dabula nyim decree economy alanko ye wolle de daten.
Ousted the jurisdiction of the courts and gave legislative powers to the council.
Kiti bundal deng kasembo di mol la mi alanko wollebe maralo ni wo wato kono.
That is not in consonance with democratic principles as we know.
So in
my view, I would not have touched those decrees. But your opinion is that, although you don't want to say the word savior, but you did come to save us.
I'm glad you are not me.
Indeed.
We acted responsibly.
Mrs. Bensouda, I think we'll agree to disagree at this point, and we'll close for the lunch. I'll just refer you to the chairman before we do so. We will break for the lunch, not close. We'll come back after lunch. Thank you.
Thank you, Thank you, Council, and thank you, Madam Bensouda. We will resume at 3 o'clock.